Hello, everyone, and welcome to another live Q&A. My name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin, LLP. We are the employment lawyers. If you're tuning in right now and you have questions or concerns, or you're dealing with a difficult situation at work, this is your opportunity to speak with an employment lawyer. Go ahead and ask your question. Let's solve that workplace problem if we can. At the very least, you should know what options you have, what rights you might have, and maybe even what obligations you might have as an employee in your workplace. As well, if you're dealing with any kind of medical leave or medical issue at work, maybe you need to take a medical leave of absence, maybe you're asking for accommodations in the workplace, really anything related to disability insurance or medical leaves of absence. Again, we, as employment lawyers, as disability insurance lawyers, we are here to help. We are here to answer any questions you have with respect to any of those issues. We've got half an hour to answer any and all questions you have in that respect. And again, we always welcome those questions and welcome the opportunity to help people out as best we can. Our employment laws in Canada and in whichever province you're in, ultimately, they're quite favorable to employees. They're quite protective of employees in a lot of different circumstances. But of course, you don't have those protections if you don't know what they are. And that is the starting point here. We're here to educate employees on what rights they have, what options they have when it comes to the world of workplace and employment law. And again, we're here to take any and all questions, whether it's a question about pension, whether it's a question about severance, if there are changes happening in your workplace, if you're dealing with a difficult boss or a difficult coworker who's bullying you or harassing you at work, you have rights as an employee in all of these situations. So please do go ahead and post your question right now, and we will get to it over the course of the next half an hour. Again, this is a live stream. We're coming to you live right now to tackle any and all workplace problems and employment law situations. Before I get into a couple of matters that I wanted to discuss right off the bat, and these are matters that have come across my desk over the past week or so that I wanted to touch on that I think are good lessons for anyone out there viewing. I wanted to share our contact information just to begin. I think the first place you should head if you're dealing with an employment issue is our website. You can visit us at employmentlawyers.ca. It's where you should go first. Of course, we've got all of our contact information online. You could find any one of our offices, phone numbers of individual lawyers, etc. But as well, and by the way, stlawyers.ca is also where you can go. We've got a ton of resources, blogs, news articles, employment law 101 basics, where you can start getting an initial sense of what kind of workplace situation and employment law situation you are dealing with. We have articles with respect to severance. Severance works in a very particular way in the world of employment law when it comes to terminations of employment. You are often owed as an employee significantly more severance than what an employer is going to initially offer you. We also have lots of articles about temporary layoffs, which may be illegal, about what we call constructive dismissals, which are changes imposed on you as an employee in your employment. And by the way, a constructive dismissal can lead to severance. You don't necessarily have to accept changes that are being imposed upon you at work. It can lead to a severance claim. We also have lots of articles with respect to, again, disability insurance, medical leaves of absence, what we call discrimination or human rights claims in the workplace. Again, stlawyers.ca is your starting point if you're looking to get a sense of what legalities apply to your situation. How does the law work when it comes to any particular situation you're dealing with in your workplace? I will mention as well, because it's an increasingly relevant issue, laws around and the way our laws function when it comes to harassment in the workplace and bullying in the workplace. We are seeing increasingly difficult workplace environments when it comes to how employers are treating employees, how coworkers are treating another. And again, in these kinds of situations, you have rights, you have protections when it comes to treatment at the hands of your employer in the workplace. but you need to know how the law works because it works in a very particular way in those kinds of situations. You can also email us, by the way. help@employmentlawyer.ca is the email address that you can reach us at. It's on the screen right now, as you could see. Go ahead and send us a brief email. Don't tell us the entire story of your career. Don't send us an 8-page email outlining every single thing that might have ever happened to you. Send us a short, concise email outlining what concerns you have, what situation you're dealing with, what your main question is, and we actively monitor that email address. And I guarantee you, someone will get back to you with respect to your concerns and your questions. It's as simple as a free of charge email. Go ahead and email us at help@employmentlawyer.ca. And again, we will get back to you. And in fact, we have an entire team of intake personnel and an intake team standing by to field calls, to field questions, and to ultimately put you in touch with an employment lawyer that can assist you, provide the proper guidance and advice, and get you on your way to resolving your workplace dispute. Again, that is ultimately our main goal here. We are here to resolve any workplace problems that you are dealing with, whether it might be at the start of your employment, if you have an offer letter in hand or an employment contract, and you're wondering whether to sign or not, or what specific terms of an employment contract mean, give us a call. We're more than happy to review an employment contract with you, especially if it's for a senior position, if it's for a position with a high compensation package. You want to have an employment contract reviewed before signing off. If you are in the middle of your employment and you're dealing with either changes in the workplace or you're dealing with a difficult workplace situation, again, that is a situation, I'm going to talk about one right now, in fact, that is a situation where we will be dealing with ultimately advice, guidance, etc., in terms of what can you do to protect yourself when you're dealing with a situation at work that, again, maybe changes to the terms of your employment. Maybe your employer comes to you and is asking you to change position, or is removing responsibilities and duties from you, or is perhaps changing your pay structure at work. If you are a salesperson, for example, your employer may come to you and ask you to change the compensation plan that you are working under, and that may have a negative change to the terms of your employment. Or, of course, if you are dealing with a termination at work, if you have been let go from your job, I mean, certainly that is one of the most difficult and stressful situations that any employee, any person for that matter, could be dealing with. Before you sign off on a severance offer, before you accept any severance package from your employer, you may think it's the best package that you've ever seen. It may be a significant amount of money on the table. Do yourself a favor. Before signing off on that package, speak with an employment lawyer. As I said a few minutes ago, there is every chance that what the employer is offering you as severance does not correspond to your full severance entitlements as an employee. Employees are oftentimes owed significantly more than what an employer is initially offering them. And a lot of times, those severance packages are negotiable. But of course, you need to know the way the law works in those circumstances. You need to know what your severance entitlements are. And again, you do that by making sure you speak with an employment lawyer before, not after, you sign off on any severance package. For those of you just tuning in, this is a live Q&A. We are here to talk employment law. We are here to talk workplace rights. We are here to talk rights of employees who are on medical leave of absence or perhaps entitled to disability insurance benefits from insurance companies through their benefits, of course, their benefits coverage. My name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, LLP. I'm a partner at the firm. If you're dealing with a situation at work, now is an excellent opportunity. Just go ahead and post your question right now. Keep it generic. You don't have to mention your particular employer. You don't have to go into any personal details. And I promise I will get to your question before the end of the segment. I've got a few questions already lined up. Joseph on Facebook, Michelle as well, Chris on YouTube, Kathy as well. I'm going to get to your questions and answer those questions in a sec. Before I do that, and keep lining up the questions, folks. And again, keep tuning in. I'm going to get to all of these questions in a minute. I wanted to touch very quickly on a point that has come up recently. It's come up several times over the past couple of weeks to the extent that I wanted to raise it during this live stream today. And I just spoke to someone this morning, actually, in this exact situation. The issue is signing employment contracts mid-employment. I've spoken to lots of people over the past couple of weeks who have come to me and said, Alex, I've been employed with the company for a certain number of years. Maybe it's 3 years or 4 years. Maybe it's 18 or 20 years. And their employer, out of nowhere, really, is asking them to sign updated employment contracts. And the rationale that you're given as an employee when you're offered an updated employment contract, typically the employer will say, we're just updating administratively our employment contracts. We're cleaning things up in HR. We want employees to sign off on these new employment contracts just so everybody's on the same page and we have everything organized from an HR point of view and from an administrative point of view. And that's all well and good. An employer is ultimately allowed to do that. But that should be a red flag, quite frankly, for employees. If your employer is asking you to sign an employment contract mid-employment, there is only one thing that employment contract is going to be doing. It's going to be limiting your rights and limiting your entitlements as an employee who is already established and working for the company and under current terms of employee. I will give you a primary example of the kinds of changes that an employment contract, again, mid-employment, while you are already employed with the company, the kinds of terms in an employment contract that could have a very negative effect on an employee. And the main one is termination language and termination provisions in new employment contracts. Again, I've seen it multiple times over the past couple of weeks where an established employee who either doesn't have a previous contract or their previous contract is quite old and quite stale now, is asked to sign an updated employment contract with 2026 state-of-the-art terms in the contract that ultimately limit an employee's severance entitlements in the event of a termination. If there is termination language in an employment contract that limits an employee, for example, to their minimum severance entitlements under the employment standards legislation in their province, and whether that's, any province that you're in, each province has employment standards legislation, and those minimums, may become your maximum if you sign an employment contract that said so. I'll give you a stark example. In Alberta, for example, minimum entitlements under employment standards legislation in Alberta may be only 8 weeks of pay, if you can believe it. You can be a 20-year employee, and if you sign an employment contract that limits you to those legislative minimums, the extent of your severance entitlements may only ever be 8 weeks of pay. However, if you don't sign that contract, if you have no terms of employment limiting your severance entitlements, you may be owed as much as 24 months of pay. That's 2 years of pay if you don't have a contract that limits your severance entitlements. This is a very likely difference here between 8 weeks, which may be the extent of your severance entitlements, if you sign an employment contract with termination language. Again, I'm using Alberta as an example here, right? And 24 months, which may be your full severance entitlements if there is no such termination language in an employment contract. We have seen these situations before where employers are asking employees to sign contracts that limit their severance entitlements. Do yourself a favor before you sign any kind of contract of employment with your employer, particularly if it has termination language or temporary layoff language, or allows the employer to make changes to your employment without your consent. Those should all be red flags for employees. You have no obligation to sign an employment contract with your employer, again, particularly if you are mid-employment, right? And ultimately, it is better to politely advise that you do not feel comfortable signing, right? At the very least, before you sign off on any kind of employment contract, as an already established employee of a company, again, do yourself a favor, speak to an employment lawyer, get advice on what terms you should accept and what terms you should be resisting. You need to know where you stand before you sign off, not after. If you sign that contract and something then happens or you need advice afterwards, we cannot help you once you sign. You need to receive advice before you sign off on an employment contract. Do not sign off on your severance entitlements as an established employee, or on any other rights or protections that you might have as an employee by signing an employment contract with an employer simply because they ask you to, and they want to update administratively their HR practices. All right, with that out of the way, folks, let us get to the questions for the day. Again, I appreciate you all reaching out. Joseph was first in line. So, Joseph, you're up first. Joseph says on Facebook, I had a heart attack last year. My doctor asked the company if they had a job I can do while sitting. My company said no and has not tried to accommodate me. I've worked there for 36 years. What can I do about this? Joseph, I think that's a major problem for your employer, quite frankly. An employer does have a duty to accommodate employees who have medical limitations, medical restrictions. It doesn't sound like you were asking for much, quite frankly. It sounds like you were asking for a job that you can do while sitting. Listen, the analysis is always very context specific. So I'd love to know, Joseph, what kind of job were you doing? What kind of employer is this? What kind of jobs are available to you? If there was a job that was available that you could do sitting, even if it was inconvenient for the employer, even if they had to move some employees around, even if it cost them some money to create that job for you, or some, again, inconvenience to move people around, to place you in that job that would allow you to sit and accommodate your medical restrictions, your employer has to play ball there. An employer has a duty to accommodate employees with medical restrictions and medical limitations up to the point of what the law refers to as undue hardship. That's the phrase that's used here. What that means is that some degree of hardship, some degree of inconvenience on the part of the employer is expected when accommodating employees. It shouldn't be easy. It's not supposed to be easy. And even where it's not easy, the employer still needs to accommodate the employee. Joseph, I'd be concerned here that your employer has failed to accommodate you. You would be owed severance based on your 36 years of service, which may very well be 24 months of pay, which is the maximum severance that an employee would be entitled to ordinarily. Depending on your age, Joseph, there are exceptional cases where employees are owed more than 24 months of pay. I'd want to make sure, A, that you're not unionized, because by the way, this applies to non-union, when it comes to severance at least, this applies to non-unionized employees. B, whether you had a contract of employment that might limit what severance entitlements you might have. And then I'd want know a little bit more, Joseph, about the employer, about the specific circumstances of your accommodation request. Keep in mind, everyone, accommodation requests when it comes to medical limitations, health issues, they need to come from your doctor. It's not you that gets to dictate what accommodations you need, nor is it I that gets to dictate what kind of accommodations you need. It is a medical opinion that matters. The accommodation request, Joseph, would have need to come from your doctor. And I suspect it did in your case. Joseph, give us a call at the office. Send us an email at help@employmentlawyer.ca. We need to have a chat about this. We need to make sure that if you haven't been treated fairly here, you are owed the proper amount of compensation, which, by the way, includes potentially 24 months of severance. It may also include additional damages for the failure to accommodate on the part of your employer. Give us a call, Joseph. It sounds like it's worthy of a chat. Michelle is up next. Michelle asks, is there a difference between LTD offered by an employer as part of compensation versus a privately held plan? There may be differences there, Michelle. I mean, in the most obvious way, every disability policy, shall we call it, will have their own terms. And so there will be contracts that govern what an employer might do, for example, when it comes to having its own, let's just even call them sick days, or its own short-term disability benefits that it provides, either through an insurer or even privately sometimes through the company itself, versus what a large insurance company like Manulife or Canada Life or Sun Life may have as the terms of their long-term disability benefits policy. So the specific terms of the contract and the policy, Michelle, matter. And the details oftentimes of those policies matter in a significant way. That is the difference. Those are the obvious differences there might be between one policy and one kind of type of benefits versus another, even if we're all talking about, even if we're talking about disability insurance and disability benefits more generally. Privately held plans are typically slightly more beneficial, favorable to employees. They might have better entitlements. Group benefits plan might have different entitlements there. The devil will be in the detail, Michelle. So if you're having to compare two policies or deciding how these policies apply to you specifically, again, it's another reason to reach out to us. We have an entire team of disability insurance lawyers that are very well versed in the way these policies work and have a ton of experience dealing with different policies that might apply in different circumstances and maybe even in the same circumstance. So, Michelle, if you're dealing with that kind of situation and you're in either British Columbia or Alberta or Ontario, right? And I think when it comes to disability insurance, we can practice across the province as well, or across the country rather as well. Give us a call at the office. Let's see if we can help you out. The initial call is free. There's no initial kind of obligation there to pay a fee. Give us a call. Our intake team will ask you a few questions, and ultimately we can determine whether we can help you out there. All right. Thank you all for the questions. Again, I see you, Deandra, Sean, I think it is, or Shan, Andrea. Again, Kathy, I'm coming up on all of your questions. Again, you are tuning in to an employment law and disability insurance law Q&A. My name's Alex Lucifero. I'm an employment lawyer. I'm a partner with Samfiru, Tumarkin, LLP. We are the employment lawyers. If you're dealing with a situation at work, go ahead. And number one, post your question right now, quick and to the point. I will get to it before the end of the segment. And listen, if you don't want to ask your question online, that's okay. I get it. Go ahead and give us a call at the office. Send us an email at help@employmentlawyer.ca. Get in touch with us however you want to get in touch with us, and get on the road to resolving whatever workplace problems you might have. Speaking of which, Chris is up next. Chris asks on YouTube, I believe, my employer eliminated my position while I was on disability leave. They say it's unrelated to my claim. Is that considered retaliation? Chris, I don't think retaliation is the right word. Retaliation typically means that you stood up for some, for your rights or some protections that you might have under our employment laws and were terminated basically as punishment for standing up for yourself. If you're dealing with a disability leave, that might not apply perfectly. So that's an area of law that we call reprisals. Being on disability and being let go from one's job isn't necessarily a reprisal situation, but it definitely raises some concerns, Chris. And you've kind of touched on it yourself, which is, listen, if even 1% of the reason for termination was related to your disability or you having to take a medical leave of absence as a result of any health issues, that would be considered discrimination under our human rights legislation in Canada, in any province. Right? And ultimately, there would be a severance claim on top of that, of course, as a result of your termination. Now, your employer says it's unrelated to your claim or your disability leave, Chris, and we'd want to test the evidence there, right? If it is truly completely unrelated to your medical leave of absence, right? If the employer has restructured its operations or it's downsized its company, and let's say, for example, as an obvious example, your entire department has been laid off because of a massive corporate restructuring. Well, then, Chris, regardless of the fact that you might be on a medical leave or a disability leave, your employer may legally be allowed to let you go. Because, again, in that case where it is a very obvious restructuring or downsizing, it's clear, the evidence becomes clear that it has nothing to do with your medical leave. In that case, of course, you would be owed severance, Chris, there's no doubt about it, but it may not be discrimination if it's true that it was unrelated to your disability leave or your medical leave of absence, right? But oftentimes what we will see is that a medical leave does play a role in a decision for termination, and that is where things get a little suspicious. Again, we want to test the evidence there. And I mean, regardless of whether it's discrimination or not, being on a medical leave and being owed severance can impact your severance entitlements. You may be entitled to more severance because it may take you that much longer to find that new employment if you're still on a medical leave of absence. Chris, if you've been made a severance offer or whatever the situation is, if you're dealing with a termination while on medical leave of absence, I mean, it goes without saying, you need advice. You need to speak with an employment lawyer. Give us a call at the office, please. Let's have a chat about it. These are life-changing moments where you don't want to make the wrong decision, certainly. All right, Kathy is up next. Kathy asks, can an employer punish you if you're late because of a serious issue on public transit line? There have been several serious delays on my line recently, and it has made me late for work. Kathy, it's an excellent question. And it might be a bit of a gray area, quite frankly, when it comes to the way employment law works. Can an employer punish you, Kathy? It depends what you mean by punishment. Can they issue you a warning or a write up, for example, for being late, even if transit is ultimately to blame for that? I think potentially they can, Kathy. I'm not saying it's necessarily fair, but I think an employer's response there may be ultimately you're responsible as an employee for making sure that you are on time for work. And if you're anticipating delays, it may mean you have to leave the house earlier or make arrangements such that you are not late for work. I can see a reasonable employer, Kathy, and reasonable is a key word there. Listen, a reasonable employer should be giving you some degree of leeway, right? If you're late once because of public transit, that's okay. Things happen. If you're late twice, maybe even, that's okay. Things happen, but now you realize you've got a problem if this happens once or twice. And again, you need to find a solution as an employee there. Maybe you have to find another way to get to work. Maybe you've got to leave home earlier if you know there are going to be delays. Again, you can excuse it once or twice, but if it becomes a recurring pattern, an employer doesn't have to just accept you being late for work because of public transit. Something needs to be done. Now, when you say punish, Kathy, if by punish you mean can an employer let you go, for example, terminate your employment without severance as a result of being late due to public transit delays, I would say unequivocally the answer is no. In a situation like that, you would be owed severance as an employee. Severance would be based on your age, position, and length of employment, and maybe on any contract you might have signed with the company, but it would be significant still. An employer doesn't get to pay less severance just because it may have had a reason for your termination. Ultimately, to pay no severance, an employer would need cause to terminate your employment. It's what we call a with cause termination. Cause is a very high bar for an employer. You would have to do something very terribly wrong, drastically wrong, in order to merit a for cause termination. In other words, a termination without severance. If you want a sense of what your severance entitlements may be as a non unionized employee, or if you have questions about constructive dismissals or changes to your employment, on the screen right now is a website, pocketemploymentlawyer.ca. Go ahead and visit that website. It's a tool that we provide free of charge. Answer a couple of questions confidentially. We don't take any information. Again, there's no fee. It's completely free of charge, and you will get a sense of what rights, what options you might have in the workplace. All right, over the next couple of minutes, I'm going to get to these last questions, folks. We're going to do this rapid fire, but make sure we answer the questions appropriately. Andrea is up next. Andrea says, my partner has been given a voluntary leave package due to a major decline in business. He's a 23-year employee. What would you think would be a reasonable offer for him to accept? Andrea, I hate to say it, I'm missing some information. We've got that he's a 23-year employee. However, I need to know his age or her age. And I think it's a him. And I need to know his position with the company. Again, three important factors: age, position, length of employment. How long you've been with the company? 23 years is significant, Andrew. Don't get me wrong. His severance entitlements may be significant. I worry a little about the term voluntary leave package. Hopefully, as an employee, you never want to be in a position where you're asking for a severance package. You may not have much bargaining power there, right? But if you are being offered a package by your employer, you might have leverage there. I need to know, Andrea, his age and his position, and I can give you a better sense of what kind of severance he would be expecting. Use our severance pay calculator. Again, pocketemploymentlawyer.ca is the website you want to go to. That will give you a sense of what his severance entitlements should be, and you can compare that to what the voluntary package is. And ultimately, if you want somebody to review that package, if there's a lot of money on the table, Andrea, I suggest you schedule an appointment with a lawyer. Let's make sure that we get proper advice in the circumstances. Shane or Sean is up next. What if an employer starts talking about temporary layoffs? It's been a topic floating around my company, and I've been dealing with a lot of U.S. trade issues, as many employees have, and it's impacting a lot of us. The way temporary layoffs work, everyone, is if you have never been laid off before in your employment, and you have a look at your offer letter or your employment contract with the company, and your contract doesn't say anything about temporary layoffs. If your employment contract allows the employer to lay you off temporarily, it's a term of your employment, of your written contract of employment, you may be bound by that term and your employer would be allowed to lay you off. But if you've never been temporarily laid off before and it's not a written term of your employment, you would be allowed to treat a temporary layoff as a permanent termination, get severance, and get moving on to new employment. Shane or Sean, if you're dealing with that kind of situation where you've never been laid off before and it's not a term of your contract, I would not accept a temporary layoff. That just means sitting at home, not being paid, doing nothing, waiting for a callback. Not ideal. And by the way, if you find another job, you resign your employment. You're not owed any severance in that situation. It might be better to treat the temporary layoff as a termination. Before you do that, again, give us a call at the office. Let's chat about it in more detail. I want to look at your contract. I want to talk to you about your terms of employment. We'll have to leave it at that, folks. If I didn't get to your question today, please make sure to tune in tomorrow. We've got another live stream coming up. Go ahead and email us, help@employmentlawyer.ca, or give us a call at the office. Until next time, everyone, I hope you have a good rest of the day, a good rest of the week, and take care until next time.